Welcome to another edition of the program Familiarise with the Law, coming to you from Star Television, where we broadcast from our Media One Center 3 Mama Street, Brookfield, Sweden. A program that looks at critical issues, the borders of national development, and by way of understanding the intricacies that surrounds the law. In today's edition of this program, I have as my guest the director Nimati La Sonkita Conte. La Conte, good day and welcome to this program.
Thanks for having me.
Last week we took a deeper reflection on the aspect of the review process of the 1991 Constitution, and today we continue on that trend, just at a time when the multiple views of people's contribution and inputs we have been validated, and we do seem to be experiencing a kind of a sudden halt into the entire process, and it's becoming quite worrisome for even the initiators of the very idea in wanting to have a reverse constitution, a review constitution. How much have you been following this latest trend of event?
Well, very clearly it's been topical. It's been on the news, it's been on talk shows. We understand that the review committee was finalizing the document, and it was at the printers, it was edited and was ready to be submitted once the printing process had been carried out. But then they received communications from the All People's Congress, which had representations within the committee throughout the past several years, that they had some issues with the report as it were, and that they were not going to sign, and even those who had signed were asked to withdraw their signatures. And so that has been on several radio stations. I listened to an interview by Val Nora. I also listened to a couple of other communications about that, and it's in the papers too. So it tells you it's such an important matter. People are following it very closely, and I sense that some quarters are quite worried that the whole process might be stalled because of this new development. I do not necessarily hold that view that the whole process will be stalled, and I think the chairperson of the committee, who is a seasoned personality, he's been a judge for many years, he's also been a speaker in parliament, knows how to hold the balance in these situations. And this is why you need such people. And I think what he's doing is essentially giving them the benefit of the doubt by giving them, the opportunity to hear, to air what they think is problematic, and then for the committee to make a decision.
Perhaps what I found extremely difficult to understand is the aspect as to whether other political parties that joined the fray in reneging to sign the very document, whether in the first place one they did so out of their own volition or they were coerced. I'm not sure, because I spoke to some representatives from other political parties. What they expressed duly was that they too, we are not satisfied with the entire process, given that the views of people we are not captured adequately. Those were their words. So to say they were asked not to sign presupposes it's an element of coercion.
Well, I would say it sort of shows that there is a common theme, a common thread, because these individuals were representing a bloc, a political party, and the party would have its own position on some of these issues. And if you recall, the party did submit a position paper to the CIC, setting out what its issues were and what it would like to see included in the revised report for the Constitution. Now, one thing I'd like to point out, Raman, is the fact that the process of agreeing on a constitution is one that is born out of compromise. There is never going to be unanimity on all the issues that are going to be addressed in the Constitution. And there is never going to be space in that document for every single view that is expressed to the committee to be captured. The Constitution is a framework law. The Constitution is the supreme law of the land. It cannot possibly address every single issue within Sierra Leone. And so what you aim for is a workable document that is not very bulky, that really speaks to the big things, the big picture issues. And then those issues and other issues that are not addressed within the Constitution could be dealt with by other laws. So, in as much as I understand why people want their views to be in the Constitution, I mean, we have to be realistic that it is not possible for every single view to be represented in the Constitution. Otherwise, we could have a 40,000 page document. And so, what is essential is that the Constitution really speaks to the aspirations and the principles and things that we hold dear as a nation. And once we have those, we could then begin to fashion laws that reflect those principles. So I am not overly worried about those concerns that the Constitution needs to address every single view that is sent to the CRC.
Well, Laconte, you were overly worried in a situation where there was an insistence, especially so when it comes to dealing with the right of women in land acquisition, where contributions were being factored as to what needed to be done when it comes to enhancing and empowering women in that regard.
Mm-hmm.
It was an aspect where I don't want to see it as a challenge, but you submitted a paper in furtherance by way of asking for more leverage to be given where right of women, especially in land acquisition, must be guaranteed. You were overly worried.
Absolutely, and as I mentioned, I just talked about certain big picture issues, certain fundamental principles, and so a constitution should embody issues relating to rights and freedoms of the individual as well as of groups. And in this particular respect, it makes sense and it's imperative that our constitution captures issues relating to the rights and interests of women as well. So these very big relevant issues need to be captured in the Constitution. But at the same time, we've got to be realistic that not every single issue would be captured in the Constitution. Now, you talked about the issue of women's rights. Mm-hmm. Now, the Constitution would make a generic statement or provide generic protection of women's rights. Now, it would not spell out very clearly every single aspect of the rights of women in relation to land, in relation to employment and things like that. Now, what would have to happen is that in subsequent laws, we would flesh out the generic protection of these rights in the Constitution so that we begin to give depth and data to what the Constitution envisages. So what you're looking at is not a document that really speaks to the granular issues pertaining to a matter that is being discussed. So we would have a situation where the Constitution would very broadly protect the rights and interests of women, the rights and interests of minorities. It would also protect the it would ensure the independence of the judiciary, not in a very granular manner, but then in subsequent legislation and in regulations, you would work out what that protection is about.
Okay. I managed to talk to Valnora Edwin. She belongs to an organization, one of these organizations that had a representation in the 80-man committee. That is the Campaign for Good Governance. And what she related to me as a matter of contention was the aspect of the clause that stipulates the executive authority of the president. There was an attempt through a consensus to have the powers of the president being slashed. Concentrating much more powers in the hands of the president could be delicate to a large extent. And I'm sure that is the center of gravity where, they feel, in this case, the 80-man committee, not the secretariat, the 80-man committee, through their divergent views, they fail to make a commonplace perception in that regard.
Raman, I wouldn't say the whole issue was about or is about the...
One among so many.
Yeah. I mean, on that particular issue, about the powers of the president, I think that is clearly spelled out, and that will be clearly spelled out in the proposed constitution. I think, for me, that particular issue was about description. How would you describe the office of the president? Mm-hmm. So I understand that the All People's Congress wanted the rendition supreme executive authority, and others had differing views. that they would rather settle for chief executive authority. And quite frankly, that's semantics. Supreme and chief. What are the meanings that are associated with that? Now, I understand again why the CRC wanted to deal with that issue, in light of the situation we had with the elected vice president, Sam Sumana, and the issue that went to court and the pronouncement of the court about what supreme executive authority meant. So the committee, I think, very admirably was trying to respond to those challenges. And I think it is reasonable for that committee at the time to want to respond to that issue, which for a number of weeks left us in some sort of political uncertainty. And I respect the view that they would like to address that issue in the proposed constitution. So that
do you equally respect the view that, irrespective of the APC being the current establishment, their views ought to be respected equally so?
Absolutely. I think the views of everyone should be respected. But when it comes to which views make it into a particular document, I think there should be a number of issues that you consider. Now, in the past, I had written about having an objective criteria, and I had discussed some of these issues with other CSOs that are interested in the process of constitutional reform. And one of the things I had raised in the past was, how do you determine what makes it into the report of the CRC? What criteria were they using? Was it based on the number of submissions that they received on a particular issue? So if 40 people submitted position papers saying yes, and then 20 submitting these papers saying no, would they accept the 40 submissions or the 20 submissions? Is it a question of numbers, or is it a question of quality of arguments? Okay, and I think these are some of the issues that were not properly set out during the formation of the committee. That how would you determine the process by which you include things into the draft report? And again, I think this problem is going to plague us going forward when it comes to writing out a reviewed or revised constitution. And I have argued in a couple of op-eds that we need to have beforehand an objective criteria for determining what provisions make it into the constitution, because the constitution cannot be the document that takes everything on board. So how do you determine what makes it in and what does not make it in? And you need a process that is fair, that is objective, that really speaks to people's views, so that when we say, unfortunately, we can't include this in the constitution, we would have reasons for that. So I think, this for me is a precursor of some of the challenges that we would face when we begin to think about writing the constitution. And again, I must reiterate the fact that the last time I called on the government not to make this writing of the constitution a government-only process. Now you begin to see the sensitivity surrounding that. So this is a clear sign that when it comes to the writing, it shouldn't just be the reserve of the government or the law officers department. They need to have a much bigger body representing different interests and people who have what it takes.
Well, again, to the lay public, as you talking now, someone will say is a question of technicality. There are issues that seem to be quite technical that could only be better handled by lawyers.
Sure, but then there are also issues that could be dealt with and made more clear by other experts as well. So there are issues on land and environmental justice that the Constitution would seek to grapple with. It's not just the domain of lawyers. What I would like to see would be representation from the relevant constituencies coming into draft this revised constitution, rather than just it being submitted to the law officers department's drafting department for them to write something out and send it to people. Because again, we will begin to question, why did you leave A out and not B? What criteria did you use to include this and that into the revised draft? I tell you, the report as it is very bulky, and not everything in the report is likely to make it into a revised constitution. So it is important that we have these criteria in place that will determine what goes into the revised constitution.
Lason Kita, I hold this impression until proven otherwise that in a situation where we agreed as a nation for us to have eliminated what constitutes some of these encumbrances, let us look at the 1991 Constitution from a broader perspective, and look things that are not workable within, infuse things that seem to us being working, rather than us having an entire process that could give rise to an 80-man committee, the establishment of a secretariat. It's just a kind of consensus as to whether we need to, for want of word, put and pull, rather than us going into this entire process. Because of fear about the general public now, the whole process is about to be stalled.
I would disagree. I think I am an eternal optimist. I always see the glass half full rather than half empty. And I think this is not going to stall the process. It's symptomatic of any major process of consultation and consensus and consent seeking. I was not deluding myself then, and I wouldn't now. That it's, if you have consensus within the 80-man committee, that is magical, that is fantastic. Now, what you should aim for would be that the majority of the people within the committee are satisfied with the process. You actually don't need all 80 of them to sign up to say, we absolutely agree with all of the things in there. Then there might be some problems, quite frankly.
I will not let you know what your colleague, Lawyer Solomon Jamiro, related to me when I put forward this question to him that I'm going to ask you here. What's your view about the 1991 Constitution? Is it a bad constitution, or is quite challenging within the context of its applicability?
Well, I think first off, I would say it is not a bad constitution. It's not a bad law. I mean, for its time, it was impeccably progressive because we were coming out of a one-party system and moving into a multi-party system. Okay, so it was, for its, at that time, it was really progressive. And it has done well to serve us over these past 20-odd years. And like many things, society changes, time changes, and things change, people's needs become different. And if the law is a living thing, and which we hope it is, then it must be able to adapt to these changes. And that is why you find that many countries, after a period of time, they will look at their laws that they have and determine whether or not those laws are addressing the current needs and aspirations of people. And if they're not, then they would seek to change those laws. And I think it's imperative that we periodically undergo these kinds of processes, especially for the big law, the Constitution, which governs us all. I think it served its purpose. I think we've learned from a number of the issues that we've grappled with over time, the issue of the elected Vice President Sam Sumana, and other challenges that we've had in the past 15 to 20 years. So what is important now is for us to take a look, as we are doing now, at the Constitution and see how we could plan going forward for the next 20, 30 years. And it's not a bad law at all, but I think it's in need of review. We have learned a lot of lessons. We could draft it better. We could include more provisions that protect the rights and interests of women. We could include more provisions that protect the rights, the environment, the rights of persons with disability. I mean, there's so much we could do with a new constitution. There's so much we have learned over the years that we could infuse into this this proposed draft that would put us in a good stead to make giant strides into our future. So it's not a bad law at all by any means, but we could have a better one, and I think that is a process on which we are embarking on now.
I would also suggest for one that the current infraction we seem to be experiencing in the process could be politically motivated. I don't have evidence to the effect. What I hold as a very solid impression here is a very fact that there is an insistence on one set of individuals that want their views to prevail, while there is a persistence on the other that our views must prevail, even within the 80-man committee. So there is a question. There is a battle of wits as to whether my stance could prevail as opposed to the other. Now, what is required of us as a nation? It will not augur well and will hold responsible, especially 80-man committee that constituted the body that should guide the entire process, will come to that conclusion and say, you know what, we are not defeated in our objective, perhaps we are betrayed. I was looking at the mix of lawyers in that particular committee that should have helped, because they have the wits around them to actually understand what constitutes the good things and the bad things.
I think
to actually help the situation and guide the process.
No, but I mean that's never going to happen because lawyers would have different views. Definitely, you would have black and white and grey as well. Now, one thing that I don't understand is that people are overly pessimistic about this whole thing. Now, the very nature of the committee would lead you to believe that there are, along the process, along the line, would be contentions. Because the committee was seeking to get representation from various groups, various constituencies. So the fact that you began with that means that you're trying to bring all shades of opinions together. And there is always a possibility of those opinions clashing. So you had political parties, you had academics, you had lawyers, you had market women, you had all other pressure groups. So basically what you were doing was bringing all these different views together to see how they could contribute to a document. Now, there was no guarantee at the start that these views would not rub themselves differently. And this is what we've seen. Most people are questioning the timing of it, that, oh, now that we are finalizing the whole thing, that's when these issues are being raised. They could have been raised earlier. For me, that is not an issue. Even though time is of the essence and we need to move very quickly, I think I endorse the move of the CRC chairperson by saying, let us have your views in writing, and then they have submitted that. We would call one more plenary meeting, and we would discuss those views. Now, if those views are justified or they're not justified, this is how we would deal with them. But I don't think that should undermine the process. Now, I told someone the other day that the process of agreeing on a new constitution or a treaty at the international level is a political process. So people should not delude themselves.
Meaning?
It is a political process that involves, it's give and take, it's compromise, it's about relationships. So I would want, as best as I could, to get my views imprinted on that document. Because for me, it's about posterity. Once I have my views in that document and it becomes ultimately the law of the land, then I feel very proud that I have represented my constituency well. So I don't hold any grudge against those parties that want to really represent their views. They could do that in a respectable way as they're doing now. Okay? But there is no compulsion that those views must be accepted into the final draft, because it's a question of compromise. And the plenary, which has the mandate to look at that, would examine those and determine whether or not they warrant inclusion in the final draft. Now, if the APC feels very strongly about that, and the plenary does not know what to do, I think it's simple. You can still have your draft report, but then annexed to that report would be reservations by one of the components of the committee. It's as simple as that. So the APC could still sign up to the report, but then they could attach their reservations to the report. I mean, it happens at the international level when countries negotiate treaties. Now, some countries may agree with 70% of the provision of the treaty, and they would sign up to the treaty, but with what? Reservations. They would say, with respect to these issues, this is our view. We don't think it should apply to us. But then they would go ahead and sign it, and that would not affect the treaty coming into operation. So I don't think this should be a matter at all. So if the APC still insists on having its views in the report, I mean, that should not alter the plans now. They could have an addendum to it, which is reservations of the All People's Congress representation to the CRC. But then they could go ahead and sign. So you would deal with the issue of, we had these views, and they were also accounted for in the report, because the report would be there, but then their own reservations would also be there. So this should not pose any serious challenge to the process, because a lot has been invested into that particular process, and we wouldn't want any excuse by the committee to us for not delivering the final product.
Principally, I was looking like any other person at three key elements here while we're moving gradually to the period 2018. One is the conduct of the general elections, both presidential and parliamentary. That is one. Two, the yet to commence process of national registration, where the attempt has already been made by government to having all of the biodata of individuals in the state to be meshed into one single document. That is two. And the possible referendum, until now, which the process has gone into convulsion. It's quite interesting. I don't know whether the stalling of the process, in your words, you don't like it, that you don't see it to be stalled. Whether it's a threat to the conduct of the election, I'm not sure. The election can still go on, right?
Absolutely.
Any other winning party that could form the next government come 2018, God knows, will take the process forward.
So definitely, the thing is, we're not working in a vacuum. We already have a legal system. We have a body of laws. We have the 1991 Constitution. We've conducted many elections under this Constitution, so it can still serve for the next one. Now, however, for me, when you make your plans and you have set objectives, it is always very sweet if you hit those objectives. And so, the committee has gone through a number of challenges. They've had significant hiccups in accessing funding on time and having and reaching people the way they really would have liked. So we've gone through all of those things. Those are water under the bridge. However, the process is now nearing its conclusion, and we need to really make sure it happens. But in the event we're not able, given the time constraints that we're facing, to really go through the processes properly, then there shouldn't be any haste at all to compulsorily have a new constitution before the next election. Now, we don't want to, rush and push people into things, because mind you, the drafting process is coming on. And as I mentioned, I would like to see an open, transparent drafting process. One that really speaks to the interests of the different constituencies. One that really takes on board the views from other quarters, not just the view from government.
In other words, people-centered.
Exactly. I wouldn't want some law officers sitting in a room and going through the report and taking some stuff and putting it in constitution. I'd like to see a much better process than that. So that would take some time. So assembling that small body of drafters and representing those views would take quite a bit of time. At the same time, you would want to get people to understand the draft constitution once it's out. So there has to be some periods of sensitization built into it, okay, before you begin to go through the process of taking it to parliament and then coming in for referendum and things like that. And you mentioned a couple of events, but there are others too that are in the pipeline. I understand that it's going to be a process of de-amalgamation of chiefdoms. So we would have more chiefdoms now than we currently have, and perhaps an extra district. Now, all of these things are they are quite taxing on state institutions, and they require quite a bit of planning and resources to go into making those happen. So I think we shouldn't be in a hurry. That we need to have this out now. We need to do this. We need to do that. If we don't have the resources at hand, if we don't have if we don't have the time to go through the processes properly, then let's not be in a haste. We could have the report out. We could have elections under the current 1991 Constitution. The next government that comes in would have another sweet 5 years to look at that and then do the process properly. And hopefully, by that time, our finances would have improved. Because at the moment, we are on oxygen, as a country. We require quite a bit of economic support. And all of these activities are going to drain the economic base of the country, of the government.
So against this backdrop, what as a nation do we really ought to have learned? In terms of enhancing our democratic principles and values,
a number of things would come to mind readily. So one, I think we should have learned by now, if we haven't, the value of compromise. Because it is important that you know that your views are not absolute. You cannot force your views down the throat of every single person. There are times when you need to give and take. You need to move from your position. So that's something that we have to learn. And the CRC process really has brought that out very clearly. That you need to compromise. But at the same time, as you're doing that,